SJC-10863, Commonwealth with Vincent Wadlington.
All right, let's proceed. Yes.
May it please the court, Amy Belger for Mr. Wadlington. Good morning, Your Honors. I'd like to start by saying I was grateful to receive a call from ADA Zelnick earlier this week indicating that the Commonwealth plans to concede issue 1 in my reply brief regarding the merger of one of the felonies, the underlying felonies that Mr. Wadlington was convicted of, merging into the felony murder conviction by law under the case of Rasmussen specifically. There's 2 felonies that could possibly merge. We have the armed home invasion and we have the armed robbery. From Mr. Wadlington's perspective, as the sentence on the armed robbery was less, he would prefer to have the armed home invasion merge. And I make an argument under Rasmussen that the narrative of the case suggests that that is the one that would most naturally merge. However, I'll just point out that there is an issue in my brief regarding the sufficiency of the evidence on the armed robbery charges as well. And my sister has indicated to me that it's the Commonwealth's position that they would rather have the armed robbery count, the armed robbery count merge into the felony murder, so I will leave that to your honors to decide. But I was grateful to receive that as I prepared for this argument today. I'd like to start by discussing the voluntariness of Mr. Wadlington's statement to law enforcement. The setting that Mr. Wadlington in was at the time when he spoke to law enforcement in this case was custodial. Although he was in a correctional facility at the time, he was subject to restraint that went beyond mere incarceration, which made the statement custodial. That was a finding that was made by the motion judge, and it was because one of the correction officers acted in a way that made that true, which distinguishes this case from Smith. And that was, he told Mr. Wadlington to sit down and listen to what these officers had to say. And as these are the people who have control over his day-to-day dealings, his everyday life, unless something changes for the rest of his life, that is a very coercive situation.
The judge found that it was a custodial interrogation.
Yes, the judge did. The Commonwealth argued to the contrary in the brief, which is why I raise it at all at this time, and start off by saying the context through which I'm going to discuss the voluntariness and what went on with Mr. Wadlington's statement is that I am assuming custodial interrogation as I do that. So what happens when Mr. Wadlington comes in is the first thing that happens after he's told to sit down and listen is he is misinformed about a form that they're asking him to sign in connection with this interrogation, which is the consent to meet and rights form. The form is worded as I, Vincent Wadlington, have not been coerced or otherwise forced into this meeting against my will. And the correction officer tells Vincent that simply, this is just a form that says, telling him who he's meeting with, so sign it. He didn't sign it, but it is indicative of the way this procedure was conducted. And, you know,
But the fact he didn't sign it, doesn't that suggest he didn't feel coerced? If he had...
It does not. It says, the form says, I do not feel coerced. And he said, I'm not, or he did not sign it. The implication being, I hereby am being coerced. Okay? And the correction officer tries to say to him, Vincent, it's just, you know, this is the form you sign to say who you're meeting with. This is, and
He feels coerced, but he's not so coerced that he won't resist.
Well, again, this is a situation where he is being overborne by the fact that he's being told he's going to stay in that room by guards who control his everyday activities, and again, unless something changes, for the rest of his life. It is not really, it's not even, it is far more coercive even than cases where you find, people come into precincts off the street when they're otherwise at liberty, and it's found, well, they were free to leave. This is a far more intimidating, coercive, and overbearing situation than that. Vincent did not feel as though he had any choice, which is indicative of the fact he's not going to sign a form he's looking at that says, I, Vincent Wadlington, am not coerced to be here right now.
But what does that get you beyond the custodial?
Well, it gets me the custodial, and it gets me the fact that in Vincent's mind, at that point, he is feeling intimidated and overborne, and then we continue with, he's then incorrectly advised of his Miranda rights. And the fifth Miranda right that is at issue here, I recognize and appreciate is not the Miranda warning that necessarily is mandated. However, under NOVA, if it's given and that warning is not given correctly, then there is a problem in terms of.
Well, it might bear on whether it was voluntary.
Correct.
But that's just a factor.
What this case has here, Mr. Wadlington's case, is the missing piece from NOVA. Novo. In Novo, you had the exact same problem with the rendition of the Miranda rights, given the exact same way, in fact, by the exact same law enforcement officer. This is the same detective, again, Serpa. And what's notable about this is, I strongly encourage you to watch the way this man conducts himself on the videotape when he interrogated Vincent and the tactics that he used. It's not like there's any question of whether he knew that he was not supposed to be doing that. You published an opinion telling him not to do it 20 years ago, and he's still doing it. He's conducting his job the way he wants to do it, as opposed to the way you want him to do it. And this is the type of law enforcement officer that, actually bears, the brunt of injustices and overturned convictions and what this is all about. To the extent that there's blame to go around here, it's on guys like this. And he is the one that, once again, incorrectly administers the Miranda warnings. And unlike the defendant in Nova, Mr. Wadlington actually says right on the tape and exhibits for all to see his actual confusion about what his rights are as a result of that incorrect administration of his Miranda rights.
Here, there seems to be some confusion, at least I'm confused. I haven't watched the video, but apparently the judge made findings that were incorrect about the fifth Miranda warning, that it wasn't actually given to him orally, that was on the form, but she said it was given, or I forget who the judge was, but the judge said that it was given orally, but the judge is wrong. It's not the same as on the video.
It is, it's on.
Clarify that?
Yes. It's wrong on the form. I'm sorry, he's given it.
Given the fifth one on the form, but not orally. Is that right? I don't understand what the problem is with the judge's finding.
Right, it's wrong, it's wrong on the form that he's given. And then from the video, you can't tell. Okay, there isn't anything on the video that it's given correctly to him. It's never given to him correctly. So the argument that I take issue with.
How come you can't tell from the video?
Because it's not there. I think the argument from the Commonwealth, and my sister will correct me if I'm incorrect, the argument from the Commonwealth was, well, it was given, when the argument is given that it wasn't given, it was a different medium it was given in. And it wasn't. There isn't any evidence it was given in any medium correctly. The record does not reflect a correct rendition of the fifth Miranda warning in any medium.
So the video does not reflect the Miranda recitation?
Correct, no. Not a correct rendition of the fifth Miranda warning. It's not there. It isn't.
Did they go through this all?
Yes.
Verbally with him, as well as what was on the paper?
It was just what was on the paper that went through, and then when Serper gives him his warnings, he's not reading it from the paper.
Oh, okay.
But, yeah.
And so when he's giving him the warnings and he's not reading it from the paper, he doesn't give him the Fifth Miranda warning at all?
Exactly,
Okay,
exactly.
okay. And,
So-
and then Mr. Wadlington does not sign the form, right? Or does he?
He signed yes, he did sign the Miranda warnings.
He
form.
did sign the form?
He didn't sign the consent to sit down form.
Okay.
So what we had in terms of suppression by Judge Kane in this case is Judge Kane makes a finding that Mr. Wadlington's rights were violated because he was not properly informed of his Miranda rights, and he, in fact, misunderstood what his rights were. But then Judge Kane
Is that what
says...
Go ahead, I'm sorry. I thought the judge found that he asserted his right to have a lawyer present, and at that point, everything else after that should have stopped.
Well, he said that, well, here's what he said. He said, Vincent understood that he could only stop answering questions if he had an attorney, that the two are tied together. When Vincent says, I don't want to answer questions without my attorney present, he says, well, that's when Vincent decided to stop answering questions. So even though he misunderstood his rights, I'm only going to suppress everything after that. And what I submit to you is that's splitting a hair that can't be split in this context. If at the inception of that interview, Vincent had an understanding of what his rights were in this setting that was erroneous,
And what do you say he understood the rights as being?
that he couldn't stop talking unless it was to consult with an attorney. And he makes that very clear, that's his understanding of what his rights are. And he's to sit there and keep answering questions unless his reason for stopping is he wants to consult with an attorney. And that was the finding, and that's the understanding from Nova, from the Nova case with the same detective, again, that you can't do that. That is improper, and that is not the way to administer Miranda rights, and it causes prejudice if we can show that the actual misunderstanding influenced the defendant's voluntariness in terms of
But here what happened, wasn't it, that it wasn't so much that he was answering questions as that he wanted to know what was going on, right?
In the beginning, they tell him he's sitting down, okay? Even if he wants to leave, he's not leaving. They say, have a seat, Vincent, sit down, you listen to what they have to say, okay? So he knows that's where he is with this. He's sitting down in that chair, and these people are telling him he's going to listen. So he says, all right, I'll listen to what they have to say, but I am not agreeing to this. I'm not agreeing to do this. So in terms of his verbiage, that's what you have. Is there ambiguity about whether or not that is voluntary by him at that point? There absolutely is. And when there's not unmistakable clarity, Your Honor, in that setting, that statement can't be deemed voluntary by this court. Now, in terms of the violation of his Miranda warnings and his clear misunderstanding of what his rights are, it's not enough for Judge Kane to simply have suppressed everything that came after Vincent saying, I don't want to answer questions anymore without my attorney here. From the beginning, from the very inception of that interrogation, he had a misapprehension of what his rights were, and that misapprehension is attributable to law enforcement who more than knew better than to do that and did it anyway in the hopes that they would get exactly what they got, which was an involuntary statement they knew they weren't entitled to, and they had no business getting, and that they'd been told by this court not to do very clearly going forward. That was intentional, it is insidious, And it goes right at the heart of what the Fifth Amendment right is all about. That people have to, if they're going to speak to law enforcement, do it free from coercion, free from intimidation, and do it intelligently and voluntary.
Now, the judge, though, when the judge points to him saying something that sort of goes the other way, right? Because at some point he just said, I'm not going to say anymore without my lawyer.
Yeah,
So he, you know, which is sort of contra to the, I can't stop talking unless I am doing it to consult with my lawyer. Because he certainly wasn't stopping to consult with his lawyer at that point. It was just, I don't want to talk without the lawyer. You know what I'm saying?
I do. What he was entitled to know from the beginning is he didn't have to answer any questions at all, irrespective of whether he had a lawyer or consulted with a lawyer. He didn't know that, and he was told something different from that. And what impact that had on his voluntariness should be of great concern to this court. And the statement that you just made, he said it a couple of different ways. Actually, he said, you know, I don't want to answer any more questions without consulting with a lawyer. Or, you know, I'm not agreeing to, I want to leave, I want to speak to a lawyer. He uses double negatives in his verbiage, and there is ambiguity there about what exactly he's saying. He is not the model, as the cases have pointed out, of linguistic clarity in this context. But it is very clear, you know, by Supreme Court precedent in Davis, that he does not have to be. This is not the setting where we're going to parse out and demand linguistic clarity. If there is any ambiguity of what he's talking about, that ambiguity is to be resolved in his favor. This is an uneducated man. This is a confusing set of circumstances. He is intimidated. He is frightened. He is crying on the tape. He is clearly not composed and you know, not thinking you know, the way that he is capable of thinking when he is not subjected to this type of intimidation. And that all has to be taken into consideration here as you evaluate the situation. And I encourage you, really, to look at the videotape. I think it speaks for itself, and there really aren't words. And it's not a productive use of this time to you know, to try to use adjectives to describe what's going on. You can see it there. Just one other issue in terms of the consent and the voluntariness too. There is a point when he gets up and he leaves the room. And there is a suggestion by the Commonwealth that that goes towards his voluntariness and his freedom to participate. I'd ask you to watch that tape very carefully. He leaves the room. You can hear crying in the hallway. You can hear discussion. And then you can hear him being escorted back into the room by the corrections officer. That is not the type of voluntariness, I believe, that the law is talking about when it says you are free to leave. He's only gone a matter of minutes, if that, and you can hear it, even though you can't see it. He is not a willing, you know, he's not willingly returning to that room. It's the corrections people that are bringing him back in there.
And is there any statement that was admitted after he came back to the room?
There was, yes, there was, because that was not, I am not positive. I am not positive. I believe that it was after that that he said, I don't want to speak until, I believe that is the case, yes. And another thing I would just note, too, that you'll see from that detective, and these statements were surprised, I'm going to spend a second on this because these statements were surprised. He had to ask 3 times to, you know, to end the interview before the detective actually let him. The detective wanted to get in a few more, you know.
It's not relevant what the detective wanted to do. The judge ruled as soon as he asked, it was over. and nothing could come in.
I
after
understand. No, you're right about that.
In the brief period of time, I know that your primary argument, at least your first argument, related to the information concerning the change in Fields' testimony, or about whether it was Brockton or New Bedford. What I didn't understand is, what would Mr. Krowski have done differently if he had gotten that information earlier?
Two things. The information certainly was relevant to the motion to suppress hearing, in terms of, Willie Fields' credibility and the information that gave rise to the finding of probable cause. Secondly, I recognize that there's use of the information in the record on cross-examination, in terms of impeachment. I recognize that he used it at trial. But there's a difference between finding this out as you are at trial, okay, that there's been this material change in one of the Commonwealth's key witnesses' testimony, if you accept that that's when he found out about it. And
The judge
having-
made findings to the contrary, though.
He did. He did. I would also ask you to look at this, what went on here, in the context of the ineffective, and I know I'm out of time, the ineffective assistance of counsel claims. There's a list of them, in this context, where we have errors and whether there was a substantial risk of a miscarriage of justice. Assuming the Commonwealth is correct, that the judge was correct in saying this was turned over in September. This was not, he did not find out about this at the opening statement of the trial in terms of defense counsel. What kind of attorney who's trying first-degree murder cases isn't keeping track of the discovery that he's receiving, such that he's now putting an affidavit saying it was a huge surprise to him to find out about this in the Commonwealth's opening statement? And when you look at Mr. Wadlington, clearly, by virtue of the fact this was raised at all, he didn't know about it until he was sitting in the chair at his Murder One trial, and he finds out for the first time about this material change. And doesn't he deserve better in terms of defense in a case like this?
Thank you, Counsel.
Thank you.
May it please the Court. Eva Zelnick for the Commonwealth. I'd like to focus most of my argument on this whole interview that took place at the Plymouth House of Corrections on January 12, 2006, and start with the argument that the setting was, in fact, non-custodial. Of course, the Miranda warnings are only necessary if, in fact, the setting is custodial. While the motion to suppress judge did find that the setting was custodial, again, a lot of this is going to have to do with you going back and looking at this tape, which I hope that you will. Generally, when this court considers whether or not a setting is custodial or non-custodial, it looks at the factors enunciated by this court in Groom. Those factors include the place of interrogation, whether or not the officers have conveyed to the individual that he's a suspect in a crime, the nature of the interrogation, whether it's a adversarial type of situation, or whether the officers are building a rapport with the individual, and whether or not the individual was free to end the interview. Now, this court has also said in Commonwealth v. Larkin and again in Commonwealth v. Smith that it's a little bit different, or you add an extra consideration when the interview is in fact already taking place in a house of correction, as it was here. And then the court said the consideration is whether the prisoner was subject to some additional restraint than those normally imposed on him by virtue of being a prisoner. If you look at the reasons that the court in Smith said that the setting was non-custodial, you will find that they almost perfectly mirror the factors, the setting here. There's one factor the court says that the interview in that case took place in a neutral room in an open part of the prison. I don't know the layout of the House of Correction, the Plymouth House of Correction. So putting that one aside, when Mr. Wadlington came into the to the room, he was not handcuffed. He was not handcuffed during the duration of the interview. The interview, despite the characterization by the defense, was conducted for the most part, for the first 2/3, was conducted in a cordial manner. The officers, Detective Serpa even said to the defendant, "We want to build a rapport with you by asking you some questions."
Let me ask you, I don't remember Smith, but in Smith, did the correctional officers play any role in encouraging the defendant, the prisoner, to take part in the interview, to just sit there and listen, as they did here? I mean, that seems to be something that the judge really focused on here.
The judge did focus on that as well, and I know my sister spoke about that at length as well. But I think that, again...
Was that in Smith? Did that happen in Smith?
No, it didn't. So, no, the correctional officers did not play any part in Smith. However, the officers here, the correctional officers, didn't go to Mr. Wadlington and say, "Sit down, you're going to talk to these people." The exact quote is, "The two officers would like to speak with you, and if you'd like to, or if not, I'd just like to read your rights to you. You can decide what you want to do." Then he reads his rights. He reads him his rights. And just to be clear, the defendant has read his 4 required, correct Miranda rights, at which point they say, "Do you understand your rights?" And he says, "Yes." And he says, "But I want to know what this is about." And then the officer, again, this is the correctional officer still, says, "Hear what they have to say, basically converse with them, decide which way you want to go, hear them out, have a seat, relax, sit down." So I understand that there is an argument to me that there is, that the correctional officer is participating in this to a certain extent, but it's not the correctional officer saying, "You're going to sit down, you're going to listen to these guys, you don't have a choice here." And in fact, again, you have to consider this in context. Mr. Wadlington, and this was also found by the lower court judge, Mr. Wadlington wanted to know what was going on. This is not a guy who walked into the room scared and intimidated. As the lower court found, Wadlington wanted to know what the police were after, and he knew that only by continuing with the interview, he could secure more information about the officer's interest in interviewing him. Thus, by forgoing to stop the interview and by answering questions, the defendant expressed his knowing, intelligent, and voluntary waiver of his right to remain silent. So I know my sister has made a big deal about his failure to sign the consent form, but I believe, and the Commonwealth argues, that his failure to sign the consent form was actually indicative of the power that he realized that he had in this situation. Moreover, he left the interview. So any argument, and I know that we're going now from whether or not this was a custodial setting or a non-custodial setting, but the arguments, there's a lot of interplay between the arguments. So, of course, the Commonwealth argues that it was non-custodial, but even if this court finds it is custodial, he physically demonstrated his knowing his understanding that he could leave the interview, that he could end the interview at any time, because he did just that. He walked out. And he did so of his own volition. I've watched this tape a million times. I am not able to hear. He definitely comes back in crying. There's no debate about that. But I can't hear what's going on in the hallway. I can't hear anybody pulling him back into the room. An officer, a correctional officer, opens the door for him and he comes back in the room. But there's nothing, in my view, on the record that suggests that he was somehow made to come back in.
Did the judge rule strictly based on his observations of the tape? He didn't take any testimony about what occurred?
No, it was just on his observations of the tape. Exactly. So it follows that his statements here were waived knowingly, intelligently, and voluntarily. Again, just to clarify, he was given his 4 rights correctly. He acknowledged that he understood.
But he was given the 5th right incorrectly.
He was given the 5th right incorrectly, but not orally. He was, so.
Oh, but it was the form he signed.
Exactly. So just bear with me for 1 second. So he's given his 4 rights correctly, and he's asked at that point, "Do you understand your rights?" And he says yes. Then they say there's there's a back and forth between them for another second, and they say, okay, well, you just signed this paper, and they explain the consent and they explain the,
So the judge is wrong when the judge says the correctional employee reads the 5
yes,
so-called,
the judge is
that's wrong.
incorrect. That's correct.
Okay.
Yes. He has never read his fifth right orally.
Okay, but the 5th right is on the paper that
The
he
fifth
signs.
right is on the paper that he signs.
And thereafter, when he is trying to assert his right, he's doing it in a way that suggests that, you know, it sort of echoes
It
the
does.
5th Miranda right incorrectly given.
It does, but let me make a couple points about that. So my first point is, if you, again, watch the video, the defendant looks down at the paper that he's supposed to sign, but there is no indication that he actually reads the paper, and there's no indication that he actually reads the incorrect version of the rights on that paper, because then he's staring at the paper and he says, so where do I sign? Where's the part that I sign about that I understand my rights? And the detective has to actually point to him to show him where to sign. So there's no indication that he's at that moment absorbing this incorrect version of his rights. So then he does make a statement later, at some point much later in the interview, beyond the point that is the redacted version that the jury actually hears, where he says something to the effect of, may I please leave without my lawyer? But I would argue to you that that is semantics. First of all, prior to that, he's already left without his lawyer. He's already walked out of the room once, and there's nothing on the record to suggest that he's gone to consult his lawyer. Additionally, he tells the detectives at some point in the interview that either he or his girlfriend, I believe his fiancée Janelle, is actually represented by counsel. So even if he had misunderstood his rights, it would be distinguishable from cases where that, like, for example, Hoyt, where it was clear that the defendant absorbed the wrong version of his right, and that kept him from stopping the interview because he didn't feel like he could contact a lawyer. This defendant clearly knew he could contact a lawyer. He mentioned having legal counsel for some other reasons, and that his fiancée also had legal counsel. So even if he felt the only reason he could stop the interview was to seek counsel, he could do that, and he acknowledged.
Remind me what was said during this portion of the interview that was admitted in evidence that was so important to your case?
The only thing that he said, there was no confession made during this interview. For the duration of the interview.
The next day, he essentially does give a written statement, or does essentially make admissions, yes?
On the next day?
Next day.
That's nothing is ever shown to the jury, and I don't even know no, he never makes any written confession.
Oh, so nothing from the 13th?
Nothing from the 13th comes in, period.
Nothing from the 13th?
Nothing.
Oh, okay, I misunderstood.
The
Thank you.
only portion that comes in, and this is actually very important, the only portion that comes in is a heavily redacted several-minute portion of the very beginning of the interview.
What, on the 13th or on the?
On the 12th.
On the 12th.
On the 12th. That's the only thing, and the jury doesn't see it, the jury only hears it. It's only the audio version. And the only thing the defendant is doing during this portion of the interview is trying to remember and explain his whereabouts on Christmas Eve 2005, which is before and during the time the murder took place. And the Commonwealth used those statements the defendant took the stand in this case, and he also called several other witnesses. During trial, the defendant claimed that, during his testimony, he claimed that on Christmas Eve, he in fact went to Brockton. He was driven by a friend, Wendy Amos, and they were delivering presents to his various children and relatives and such. So, yes.
So suppose we think that that the whole thing should have been suppressed. Mm-hmm. What does it do to your case?
It was harmless beyond a reason. To our case, it doesn't do anything. It was harmless beyond a reasonable doubt to the defendant, and it was only impeachment evidence that the Commonwealth used at trial, and the case against the defendant was overwhelming.
I thought he had said during this section, I don't know Cole.
Yes, he did.
And then the
He denied
prosecutor
knowing-
says, then, if he doesn't know Cole, how are his fingerprints,
How did his blood get
or
into
how
the
does,
car?
yeah, you're right, how is his DNA on the side of Cole's car?
Right, so during the Commonwealth's case, the Commonwealth uses, or, I'm sorry, during his testimony, the Commonwealth argues throughout the case that there's no way he couldn't have known these people because there was forensic evidence to contradict it. He's denied from the very beginning. He denied when he took the stand that he knew any of these people. So it didn't matter that whether or not he'd said that during his interview. That was cumulative of his testimony when he actually took the stand. He said he didn't know Cole. He said he didn't know, he had never been in that apartment. He'd never been in that car. So it was entirely cumulative of other evidence. And as Your Honors noted, there was overwhelming evidence, physical evidence, forensic evidence, I'm sorry. There was a fingerprint or a palm print taken from the cellar of the crime scene that came back as being consistent with that of the defendant, and also a brown/red stain from which DNA was taken that also came back to be consistent with his DNA. And there was, of course, William Fields, who testified, who was one of the first people the officer spoke to, who's a person who initially called 911. He had been one of the individuals who'd gone into the house, 369 Hillman, for the what turned out to be the murder, but the robbery and the home invasion. And he told police that Mr. Wadlington had been involved, that they'd planned it for hours beforehand, that they'd specifically gone, he first said to one location, but ultimately testified to Brockton to get this gun, and then carried out the act.
And didn't he also say during the interview that he had never been to that location before and didn't know the people?
Yes, he denied it, but he denied all of that when he took the stand as well.
Okay, so what do we do? Of course, by then, of course, he was committed because the government had the prior statements anyway, that I've never been there and I don't know Cole. Doesn't that mean he's got a problem at trial because his DNA is found on Cole's car and in the house? And how do we know whether or not that may have affected his decision to testify? I mean, how do we deal with that in terms of harmless error? Again, I'm not saying necessarily that we're going to get there, but how would we deal with that with harmless error when a defendant now has statements which are coming in as part of the Commonwealth's case and then decides he needs to testify? Can we just say, well, he admitted to it later, so it doesn't matter, or?
Well, I think it's impossible to know what is in the mind of the defendant in this case, why defendants decide to testify or not to testify for numerous reasons. But I would just argue that if you put those statements aside and you say he doesn't even take the stand, even if he had said, oh, I admitted that he had known those people, he would have had to come up with a pretty good explanation as to why his palm print was on there was a bloody palm print that was found at the murder scene, hours after this murder was committed, and in the getaway car, a DNA in a getaway car. So it would have had to be a pretty convincing story otherwise. And there's just nothing to suggest that that was the case. And again, you had William Fields, who from the very beginning said the defendant was absolutely involved 100%. This is what we did. This is our plan. And with the exception of his change in testimony as to where he got where they went to get the gun, everything else remained consistent. I would just like to address that change in testimony very briefly in the time that I have remaining. The Commonwealth, as I argue in my brief, the Commonwealth promptly notified the defendant of the change in Fields' testimony, and claims to the contrary are clearly contradicted by the correspondence from the Commonwealth to Attorney Krowski ADA Flynn's affidavit, and by the trial record itself. Just to clarify, on January 2006, Fields told police that they had gone, prior to the murder, they had gone to get the firearm from somewhere in New Bedford. And then later, 3 years later, on September 28th, at his proffer interview, he said, in fact, we drove to Brockton to get that. Any argument that by the defendant that was not known to them is just clearly false as a matter of fact and contradicts the finding, or was rejected by the lower court judge, who found in denying defendant's motion for new trial that the defense had actually been informed. Like I said, there was an affidavit from Attorney Flynn, there was correspondence from her that was submitted as part of the record, and there was also this motion to quash that took place during the actual trial, in which there were statements, and I don't remember the exact, it's kind of a lengthy conversation, but it's, again, well discussed in my brief, where it's absolutely clear that if the defense counsel didn't know about these statements, he would have said something at that time. Moreover, I was just reviewing some of the transcripts in preparation for this argument, and there is a lengthy conversation prior to voir dire between the attorneys for the Commonwealth and the judge and defense counsel, in which the defense counsel admits he's going to fall on his sword because he's failed to notify the Commonwealth of a couple of witnesses, and he's done so at a very late time. This, again, would have been an opportune time for him to step out and say, you know, on the other hand, Your Honor, I'm just finding out about this guy. But in any event, it had no impact, and so therefore any claim that there was ineffective assistance of counsel or that it was prejudicial to the defendant, both of those claims must fail. It would have had no impact on the defendant's motion, and any motion to reconsider the search, suppression of the search warrant, because the only thing the Commonwealth had to show at that time was that the warrant met the test articulated in Aguilar-Spinelli, and showed that there was knowledge and veracity, that the officers could depend on the knowledge and veracity of the informant, which was Fields at the time. There was more there were numerous reasons why that defendant, why the Commonwealth could show that at the time, and they are detailed in the Commonwealth's brief. So if there are no further questions, the Commonwealth would just ask that this court uphold the defendant's conviction and not exercise its power under 33E.
Thank you, counsel.
All right. Hear ye,